Hello and welcome to Courts Today by Live Law. I am your host Urvashi Chauhan, here to keep you informed with the latest and most important updates from the legal world. As usual, first we will cover the top headlines, followed by an in-depth look at each update. CJI Chandrachud today bid farewell to the Supreme Court, saying that we are here only as pilgrims, do our work and leave. In the AMU minority status matter, the Supreme Court has held that minority status is not lost merely because an institution was created by statute. After Supreme Court wrap, Centre has doubled penalties for stubble burning. Farmers are now to pay up to 30,000 for violations. The top court has asked a Kuki organization to show materials indicating authenticity of audio clips against Manipur Chief Minister. The Supreme Court has held that unilateral arbitrator appointment clauses in the public-private contracts are invalid and selection of arbitrators from PSU's panels cannot be compelled. After Arvind Kejriwal, the Supreme Court has granted interim bail to another PMLA accused for contesting elections. But it also clarified that the order will not be treated as a precedent. And the Supreme Court has dismissed a PIL seeking separate state for Tirupati. Today was Chief Justice of India Dr. D.Y. Chandrachud's last working day at the Supreme Court. As is the tradition, a ceremonial bench was held for his farewell. In his parting remarks before demitting the office, he expressed gratitude for his journey so far in the judicial system. He said, and I quote, "We are here as pilgrims, birds for short passage of time, do our work and leave. But the work which we do can leave a mark in the institution. Of course, none of us is that important to feel that the court will not survive without me. Great judges have come here in the past and passed on the baton to the succeeding generations. In that way, we sustain the institution with different people with diverse viewpoints coming to the court and passing the baton along." He also shared his sense of confidence in CJI designate Justice Sanjeev Khanna, who would be succeeding him from 11th November. The CJI received an overwhelming farewell response from the bar, with several senior advocates, Solicitor General Tushar Mehta, Attorney General R. Venkataramani, SCBA President Kapil Sibal, and junior lawyers lauding the contributions of the CJI on both administrative and judicial fronts. Senior advocates Huzaifa Ahmadi, Siddharth Dave, Dr. Menaka Guruswamy, Madhavi Diwan, Additional Solicitor General S.V. Raju, N. Venkataraman, and Aishwarya Bhati, etc. also wished the CJI. Other senior and junior members lauded the CJI's efforts towards ensuring each party was given sufficient time to be represented and women lawyers be treated at par. The bar also thanked the CJI for the pro-technology-driven courtroom initiatives, online hearings, and standing for the cause of the underprivileged, rights of persons with disabilities and SC/STs. Justice Chandrachud was sworn in as the 50th Chief Justice of India on 9th November 2022 and was elevated from the Allahabad High Court on 13th May 2016 to be appointed as a Supreme Court judge. In the case relating to the minority status of Aligarh Muslim University, a 7-judge bench of the Supreme Court delivered its verdict today. By 4:3 majority, it has overturned the 1967 judgment in S. Aziz Basha versus Union of India, which held that an institution incorporated by a statute cannot claim to be a minority institution. The 4 main aspects for consideration before the bench here were: number 1, whether a university established and governed by a statute can claim minority status. Second, the correctness of the 1967 judgment of Supreme Court in S. Aziz Basha, which was a 5-judge bench decision and had rejected the minority status of AMU. Third, the nature and correctness of the 1981 amendment to the AMU Act, which gave minority status to the university after the decision in Basha. And fourth, whether reliance placed on the Basha decision by Allahabad High Court in AMU versus Malay Shukla in 2006 was correct in concluding that AMU, being a non-minority institution, could not reserve 50% seats for Muslim candidates in medical PG courses. The majority opinion of the bench also held that the relevant test for Article 30 protection is who established the institution and not who is administering it. The issue whether Aligarh Muslim University is a minority institution as per Article 30 of the Constitution is now left to be decided by a regular bench based on this view of the majority. The court has observed that the terms incorporation and establishment are not the same. Just because AMU was incorporated through an imperial law does not mean it was not established by a minority group. It is incorrect to say that Parliament established the university just because the law says it was passed to establish it. A strict technical reading of the law would ignore the purpose of Article 30. Instead, we need to look at the actual history of the institution and identify who was behind its creation. The central government has issued an amendment to the Commission for Air Quality Management in the National Capital Region and adjoining areas rules. This amendment by the Ministry of Environment now doubles the rates of environmental compensation for stubble burning in the National Capital Region and the surrounding states. Let me tell you, according to the amendment, the Commission for Air Quality Management may now impose an environmental compensation on farmers with land holding less than 2 acres to 5,000 per incident. Farmers with land holding between 2 and 5 acres must pay 10,000 per incident, and farmers with land holding exceeding 5 acres must pay 30,000 per incident. The Commission has further issued a letter directing for strict compliance with these amended rules, emphasizing that nodal or supervisory officers from the governments of Delhi, Punjab, Haryana, Rajasthan and Uttar Pradesh must be appointed to monitor stubble burning incidents and ensure accurate reporting. These officers are also authorized to impose and collect the environmental compensation fees. This amendment comes amid Supreme Court proceedings on stubble burning related pollution. If you recall, last month, the court had criticized the Union and states of Punjab and Haryana for imposing nominal fees on farmers who violated the ban on stubble burning. The Supreme Court today heard a petition filed by a Kuki organization seeking a court-monitored investigation into certain leaked audio clips which allegedly implicate Manipur Chief Minister N. Biren Singh for instigating ethnic violence in the state. A bench comprising CJI Chandrachud, Justices J.B. Pardewala and Manoj Mishra asked the petitioner to produce materials indicating the authenticity of the audio clips. Advocate Prashant Bhushan, appearing for the petitioner Kuki Organization for Human Rights Trust, submitted that the clips had disturbing conversations and the Chief Minister could be heard admitting that he instigated the violence and protected the attackers. He submitted that though the clips were submitted to the Justice Lamba Commission, which is inquiring into Manipur violence, no action has been taken for 4 months. Solicitor General of India Tushar Mehta, appearing for the state, vehemently opposed the petition, saying that the petitioner should approach the High Court. The court has now granted the petitioner an opportunity to file the material indicating the authenticity of the clips. Bhushan today said that he cannot reveal the source but agreed to submit the tapes themselves. You are aware that violence in Manipur, marked by escalating ethnic tensions, continues to ravage the state, particularly between the Meitei and Kuki communities. The conflict, which began in May 2023, has invoked deadly attacks, leading to numerous casualties and widespread fear. A constitution bench of the Supreme Court has ruled against clauses that allow public sector undertakings to unilaterally appoint arbitrators to decide disputes with private contractors. The Constitution Bench, comprising CJI Chandrachud, Justices Rishikesh Roy, P.S. Narasimha, J.B. Pardewala and Manoj Mishra, was considering the validity of an arbitration clause which prescribes that the appointment of the arbitrator will happen from a panel of arbitrators curated by one of the parties, which is mostly a PSU in majority of the cases. The bench has held that while PSUs can maintain a panel of potential arbitrators, they cannot compel the other party to select its arbitrator from this panel. The court has also clarified that the law laid down in this present reference will apply prospectively to arbitrator appointments to be made after the date of this judgment. After granting similar relief in Arvind Kejriwal's case, the Supreme Court today granted interim bail to a money laundering accused, Subhash Prasad Yadav, for the purpose of contesting Jharkhand Assembly elections. As elections are scheduled for 13th November, Yadav has been directed to be released till 14th November, on which date he shall surrender before jail authorities by 5 p.m. A bench of Justices Suryakant and Ujjwal Bhuyan passed the order in Yadav's challenge to a Patna High Court order. Earlier, the court had orally instructed that proof in support of Yadav's claim that he is contesting the elections from Rashtriya Janata Dal be shown. Yadav's counsel today informed that the requisite documents had been filed. However, Additional Solicitor General S.V. Raju, appearing for Enforcement Directorate, vehemently objected to the prayers. The ASG argued that Yadav is guilty of suppression. When the bench referred to Afzal Ansari's case, where a BSP MP's conviction was stayed, paving way for restoration of his Lok Sabha membership and enabling him to contest next elections, the ASG replied that a good case has to be made out on facts for such a relief. He argued that Section 45 of PMLA, that is Prevention of Money Laundering Act, restricts the granting of interim bail and that campaigning for elections should not be used as a reason for courts to grant interim bail. When the ASG further alleged that Yadav obtained the order to be allowed to file nomination without making ED a party and the said order was recalled subsequently, the bench commented that returning officer should have cancelled his nomination. But now the situation was different because Yadav has been permitted to contest. The court also agreed that such relief could open floodgates in future. However, it said that Yadav has not been convicted yet and there was a presumption of innocence in his favor. Accordingly, he was granted interim bail. And lastly, adding to the PIL's praying for unusual reliefs before the top court, it today dismissed a PIL filed by evangelist Dr. K.A. Paul seeking CBI probe into Tirupati Laddu controversy as well as declaration of Tirupati city as a separate state or union territory. You are aware that the controversy arose out of a lab report made public by Andhra Pradesh Chief Minister N. Chandrababu Naidu, as per which samples of ghee supplied to Tirupati temple for preparation of laddus during the term of the previous YSRCP government were found to contain foreign fats, including beef fat and fish oil. Following this, about 5 petitions were filed seeking relief, including court-monitored probe into the allegations and more accountability in Hindu temples managed by government bodies. Last month, the Supreme Court had constituted an independent SIT to investigate the allegations. A bench of Justices B.R. Gavai, K.V. Vishwanathan said that it could not direct a separate state to be created for a particular temple. The petitioner Paul, arguing in person, defended the prayer by saying that if a country can be created for 764 people at Vatican City, why can't a state be created for 34 lakh people, which is the population of Tirupati? But the bench denied to consider the prayer, saying that in such a case, there will have to be separate states for Jagannath Puri, for Kedarnath, etc. Further, the petitioner also said that the order forming an SIT to investigate into the Tirupati Laddu controversy was passed a month back. He urged the court to fix a time limit for the investigation to be completed, but the bench refrained from passing any such direction. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.